Grace and peace, everybody. We are back. You saw the thumbnail. You saw the title. You know what we're about to do. We're about to jump into this new motion by DeMonte Kendrick's attorney, Doug Weinstein. And he's been talking about something that most of us have talked about before, that the court needs to institute a shot clock. And what I mean by that is you only got a little bit of time. They've had unlimited amounts of time. And so I think this is going to be a fun read today. So what we're going to do very quickly, the first sentence is so epic. Shout out to Doug Weinstein. I think this first sentence is amazing. So it's again, state of Georgia versus DeMonte Kendrick. Let's read this motion here. I just love it. I love it. Motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentations of cumulative evidence. My goodness, in the morning. Shout out to Doug. I cannot argue that we've been saying this. I agree 100%. Let's go, because this is not actually really long. The defendant, DeMonte Kendrick, by and through his undesignated counsel, without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. That sentence right there, hey, that's a run-on sentence that I can approve of. I can't argue. He's saying, like, look, Judge, we got to move this thing along because there's no incentive for the state to be efficient. There's no incentive for the state to move it along. Come on, let's go. There's no incentive. So we're going to ask that you set a shot clock. I think that would be cool if they had a shot clock in the back of the court saying, okay, you got to get to the point. Quick. That would be hilarious. That might be a little bit too much, but I digress. Let's go. As this court has broad discretion to exercise reasonable control over the presentation of witness and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency and presentation of cumulative evidence causing undue delay, poor decision-making by the jury, as well as harm to Kendrick and other defendants. I think this is interesting. Poor decision-making by the jury. I wonder what that meant. I would like to dig a little bit more into that. I mean, everybody catches strays today. Everybody catching strays from Doug Weinstein. YSL Weinstein. Is everybody going to catch a stray today? Simply put, the court should put a reasonable time limit, or shot clock, as I would like to say, on the remainder of the state's case. Somebody pointed out, like, the state has been going at us for almost 6 months. And I don't think they're any closer to proving that Young Thug did something as they are proving that he has dreadlocks. I mean, there's none at all. Let's keep going. The state has put and continues to put this court, these defendants, and the 16 jurors through an arduous, tedious journey. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on in trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes. This dude is petty. Oh my gosh. Not throwing shade at the Olympics, not calling out the Olympics. Y'all, come on, Doug. You are a beast. Come on, Doug. Come on. Even the Olympians getting pulled into this thing. And that the finish line of their snail-like marathon is in sight. At this point in time, this honorable court has borne witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a deliberate fashion toward a conclusion. I almost wish I was a school teacher still, because I would have my students read this. Like this right here, if I were a high school writing teacher, I would probably have my students read this and just diagram, talk about what kind of emotions this is. This is really good. This is really good. But why should the state have any need to move with deliberate speed? The state returns home to their friends, family, and loved ones at the conclusion of each day. The state lives their lives, goes to work, and gets their paychecks no matter how long the trial proceeds. Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. This is masterful. This is making me hyped to watch trial today, because I can't wait to see how Judge Whitaker tries to get past this. Doug, shout out to you, Doug. This is excellent writing. But instead of waking up to Sonny and Cher, he wakes up to a cacophony of Rice Street and the ritual of heading to court. The U.S. Supreme Court has explained the critical role of trial judge in a trial case, in a criminal case. Our cases have consistently recognized the important role of the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet the situations as they arise and do this must have broad power to cope with the complexities and the contingencies inherent in the adversary process. To this end, he may determine generally in the order of which the parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge, I notice he has this in bold, the judge may refuse to allow cumulative, repetitive, and irrelevant testimony. If truth and fairness are not sanctified, why do I make this so small? Sorry about that. Are not sacrificed, the judge must assert substantial control over the proceedings. Wow. I'm sorry, Doug, you cooking today. I don't know what Doug cooking, shrimp and grits, etouffee, bacon and eggs. Bro, he is cooking today. The state, after originally proposing a witness list of over 700 witnesses, has a list of over 100. It still intends to present in trial. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. No end of the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed and without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. As put so succinctly by the Third Circuit Court of Appeals, courts need not allow parties excessive time so as to turn a trial into a circus. After all, the court's resources are infinite and the court must dispose of much litigation. The court's resources are finite and the court must dispose of much litigation. In short, the litigants in a particular case do not own the court. Likewise, the prosecution here does not own the honorable court. The honorable court has broad discretion on the presentation of evidence and such limit the introduction, duplicative, or unnecessary witnesses by the state. As noted by the Georgia Supreme Court, we got the title right there, to provide the trial with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. All right. The Fifth Circuit, the predecessor of our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. upholding the limitation of the number of fact witnesses allowed to be presented to testify to the efficiency of a party's treatment methods. Furthermore, this court can limit the evidence under Rule 403 of our state's rules of evidence. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or considerations of undue delay, waste of time, or needless presentation of cumulative evidence. And we got that code right there. Thus, there is also a basis under either Rule 611 or Rule 403 for the court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or the needless presentation of cumulative facts or cumulative evidence. It has never been supposed that the party has an absolute right to force upon an unwilling tribunal in unending and superfluous mass of testimony limited only by its own judgment and whim. I totally agree. I'm just amazed that this has been said. I'm like, wait, this hasn't been said already? Like, nobody has called this out already? Wild. And in exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges the court to consider the ramifications of the present pace of trial and its impact on the jury in this case, as well as the defendants. While there is no doubt that the new court is moving this case along with the fastest pace possible, given the court's meritorious recognition of the limited recognized right of the state to present its facts in a manner it deems best, the prospect of another 100 plus witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia, 11th Circuit, have recognized the impact of a jury of a lengthy trial merit consideration. For example, the 7th Circuit says this: exceedingly lengthy trials lead to a reduced concentration and recollection of the event on the part of all participants, particularly witness and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and the representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable to and unwilling to take the time to sit for cases lasting weeks or months. Doug is cooking. Shout out to Doug Weinstein. Just put Doug in the chat. Just going to put Doug in the chat because Doug is crushing it. I mean, this is very, very clear. I actually am kind of surprised that this had not been said, but maybe because they now see just how bad it is and how poor their planning is. Maybe that's it. Let's go. Jurors become overwhelmed by the volume of evidence and the number by its repetitiveness. Their attention flags, their minds wander. The witnesses, there were more than 100 in the trial of the two defendants, get mixed up in the jurors' minds and forgotten. The profusion of evidence, or rather examples, makes the documentary record unintelligible. The impressions created by the closing arguments are likely to wipe out everything that went before. Jury comprehension has been found to diminish after a mere 20 days of trial. That is a very good point. I never thought about that. Like, this is kind of like with students. Like, you would not teach students hour upon hour upon hour. They need breaks. They need time to break it up. They need topics to break it up, so on and so forth. We teach a little bit of math, even though we really got to get this in. We just let them marinate on that. go to centers. When they get done with centers, they come to reading language arts. Even though I really want to crush this math, we're going to come back to it tomorrow because their brains are not able to comprehend it. I didn't realize, I wonder if there's studies that say how much jurors are able to comprehend based upon how long a trial is. Because 20 days seems pretty, I'd say that seems reasonable. That seems very reasonable that they would say 20 days. Finally, and not meaning to belabor the point, the court of Warner wisely notes, so now imagine jurors' mental state after 6 months, bearing in mind that memory loss and the psychological and cognitive problems of jurors in a super long trial compound the first problem. The difficulty of recruiting incompetent jurors for protracted trials. A less intelligent trial is heard by a less capable jury. The longer the trial, moreover, the likelier jury misconduct becomes. The jurors become bored, impatient, irritated. The judge's instructions against discussing the case before the jury retires is to deliberate becomes increasingly irksome and likely to be disobeyed. Man, this should have been given before they went on that. This should have been given to Glanville. I ain't gonna lie. While the state puts on its case, witness by witness, Kendrick and other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Man, come on, bruh. You just hurting them. Just stop. Doug, you just hurting them. You just hurting them. Meanwhile, the risk of a confused jury, unable to comprehend a years-long trial, only grows. Wherefore, Mr. Kendrick respectfully requests that the honorable court to replace a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. This the 17th day of August. All right. That's crazy. The fact that this had to be said has got to be a crime and a shame. But shout out to, I'm sorry, man, this is great. I really wish I was a teacher still. Oh, wait, there's more here. Hold on. What is this? Oh, what is this? Oh, it's just the served papers. Sorry. It's just saying that people were served this papers. Okay. Certificate of service. Okay. Sorry about that. Yeah, it's super. If you were interested in reading it and whatnot, the moderators have already dropped it in the chat, and I'll make sure I put this in the description as well for the video. Shout out to Doug Weinstein. This was excellent, man. Excellently written. I really wish I was still a teacher. I ain't gonna even lie. There's very few times my friends know. If I say I really wish I was a teacher, trust me, that might be a sign that I'm being kidnapped. But I wouldn't mind reading this with my students and get like, what are your feelings about this? Because I could really see some kids really gleaning the emotion of this story. I mean, you're sitting in jail day upon day, but the the prosecution and the judge and the juries, they get to go home, but you got to sit in jail. I don't know, man. That dug into the feelings a little bit. That got your boy, they hit the feels. That hit the feels pretty well, man. This was well done. Shout out to you, Doug Weinstein. Absolutely, because I felt that. But what do y'all think? Let's see what we got in the chat. Thank you so much, everybody who stopped through. Looks like about 700 of y'all are here. Grace and peace to you all. Thank you so much for stopping by on today. What does Erica say? I'm just jumping in. I apologize if I missed anybody. I'm glad they put a motion for something, because when is this trial going to end? Why do we need it at all? I agree. Now, I am kind of surprised that Doug didn't put like a link to like a shot clock, because that would be comical. A big shot clock back there and say, look, you got time. Time's a ticking. You got 19 days. And it's just clicking down. Whatever you get done in 19 days, that's it. It's over. And I think this is going to put some pressure on Judge Whitaker. Erica, thank you so much for the comment. This is going to put some pressure on Judge Whitaker, because if she says no, she's going to look really weird, because y'all hear it. She's irritated as all get out. She's irritated by this case. She's irritated by the ineffectiveness of the state. So she's being negatively impacted. Judge is actually giving her an opportunity to do something, even though I think she should have just did it without needing to be cajoled, but that's beside the point. So if Judge Whitaker doesn't do that, What if she gives them a bond? What if she says, hey, they still going to have unlimited time, but now they have bond? That would be crazy. That would be great. I don't think she's going to do it, but, or she just says, yes, like y'all have exactly 20 days. And hopefully she will set it. That's my prayer. Please, if she agrees with Doug, which, I mean, given what we've seen so far, I'm not holding my breath really. But if she agrees with Doug, prayerfully, she'll set the limit and not say, okay, state, how much time do you need? Because I think that will be just complete and utter, putting the wolf or putting the fox over the hen house. But hopefully she'll determine, say, yes, I agree with you, Doug. They have 20 days. Or I agree with you, Doug. You have 15 days, state, to get it going and get it done because we got to go. I think that would be great. Let's see what Sarah says. Sarah says, PD says, I said this last week in the chat. The jury will be overwhelmed. They are swamped. If you just scan through some of the witnesses that have been here in this trial, I've forgotten about them. And I can scan through them. I can go back. The jury is going to be overwhelmed. Doug said last night that the jurors are paying attention and even taking notes during the unending video jail recordings. I wonder if that's good for the defense. Okay. I'm not buying that they're paying attention. I'm not disagreeing with Doug because there's no way that you know what they're doing. But if you're trapped there and all you can do is look up at the screen, you can't close your eyes. You can't pull out your phone. You can't take a nap. So if you're trapped there and all you can do, I mean, I would look like I'm paying attention too. That's about as good as I can give you. I mean, and then writing notes, I'm sorry. I don't believe that they write notes. I mean, they could be drawing pictures. They could be writing out a grocery list. They could be doodling. They could be just a whole bunch of stuff. Just because the pen is moving on paper, again, I'm a former second grade teacher. Just because the pencil's moving on the paper does not mean somebody's taking notes or paying attention. Trust me. If you ever taught a class of 7 or 8 year olds, you know that's not guaranteed. But I'm not arguing with them at all, though. Yeah. That's wild. I was thinking of this. What does she say? She says, after this trial, I think the jury will need a psych eval. For all the information they are forced to not remember, the confusion in the courtroom, Miss Love talking in circles, the fighting, shaking my head. No argument there. I agree 100%. Boris, I never heard your story as to why you no longer teach. I'm old. I'm tired. Maybe I'll do a story about it. We'll do story time with Whitaker. I'm just tired of it. I mean, education is not what. If you have little people, education is a very interesting field, and I'll talk about it. Well, remind me, Bora Bora, and I'll do a story time with that. If I were a student, I'd love to be an intern. Absolutely. I mean, teaching can be fun, but it's a very interesting field, to say the least. Good morning there to you, Greg, and I appreciate everybody who stopped through. It is poetic justice that they are being forced. And I pray that Judge Whitaker responds favorably to this because she's been shooting them down like duck hunt, right? I really hope that she at least gives the defense this W because she's been giving out L's like we at Lululemon. But I hope she does, because this one is the right thing to do. I thought giving bond was the right thing to do. I thought a mistrial was the right thing to do. At least do this, Judge Whitaker. This is the correct thing to do, is to give these men a speedy trial. Maybe you don't need to set up an NBA style shot clock behind the bench, which would be crazy. But I do think a real bona fide time limit. You have 20 days. You have 4 weeks to get done. At least then people know that we're moving forward. That would be great. Yeah, I'm with you right here. Doug is bringing that heat. He's a literal beast. I'm going to call him a lyrical beast. He is a lyrical beast. This is well written, super encouraging. I'm sorry. I'm all about it. It's been my opinion that the prosecution has been dragging this to hoping for a plea deal. No argument for me. Facts. I do think that's it. Because eventually you're going to run out of money. And when you're not able to pay anymore, and your attorney who's been fighting for you is like, hey, yo, we got to get this thing to the end. Like, let's just cop a plea. Like, I think that's what they're hoping for. Yo, thank you so much for the super chat. Thank you so much. Doug done did the two-step on this case. I'm trying to tell you, he is dub-stepping on for sure. Oh, and by the way, thank you, Will Crump, as well, for the super chat as well. Both of you, thank you very much. Why won't the judge punish the state for repeating and blatant misconduct in the Brady implications? I'm just gonna walk away. I don't know. I don't know, because she should be coming out. She should be extremely perturbed by that. That right there should. That and the unpreparedness. I think there's some ethical violations, and just the fact that you're not prepared. Because y'all know, like me, we all chiming in today at 12 o'clock to see and hear Adrian Love give excuses for why she's not prepared. Whether it be her dog ate her homework, or we had some big storms here in Georgia. So this weekend, there was some really big thunderstorms pop up. She's going to blame thunderstorms, gerbil infestation. She's going to come up with some reason why she didn't do it. And maybe Mondo board will come up. But we all know she's not going to have it done. And we also know, unless the Lord God has done something different, Judge Whitaker is going to let it slide. And I think Judge Whitaker needs to, and I think Doug has done a really clear job here of explaining that it's your job, Judge. It's this honorable court's job to move this along. You're not held hostage because I say I'm going to have 1,000 witnesses. No, you say, no, you're going to cut that down to 10% and let's go. The best 10% and let's move it. Yeah, I mean, hopefully it will, but let's just tell the truth. That's part of why we want to chime in today. We're tapping in today to see and hear what Adrian Love is going to be her excuse today. Adorable says, love to Doug because I've been thinking the same darn thing. Everybody's been thinking it. Doug has just literally heard the cries and pleas of the best live chat on the planet, and he is just eloquently, I might say, put it into words. And I'm just going to read this sentence again. Shout out to you, adorable, deplorable, because I love this right here. Motion. I can see a student writing this, like, Mr. Whitaker, you're going too long. We need a motion to limit the state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence. Man, I need to put the little shots fired sound effect back in here. Doug, that hurt their feelings, Doug. Doug, you hurt their souls, my guy. Goodness gracious. Everybody was catching strays there for that one. Okay, I hate to say it. She will not agree. If she doesn't, then it will be her fault. A lot of this is Judge Whitaker's fault. Let's just tell the truth. She allowed a lot of these shenanigans and chicanery. If she turns down this motion, it's on her. But then also, I mean, now she's basically tacitly telling the state, y'all can take your time. Yeah, I don't know. Look, I'm sorry. There's no way you're going to convince me that that jury is truly engaged. I'm not saying that they're not looking at what's going on. I'm not saying that their pen is not on paper moving. I'm not saying that. Unless you can confirm to me that they're taking notes at 1 minute and 18 seconds, he said this. At 2 minutes and 45 seconds, he said this. And this is what I'm thinking about that. If you can't show me that, I'm sorry. I cannot. I'm not giving you that they're paying attention. I'm not giving it to you. What more than likely is happening, people are writing their grocery list. They're writing new rap lyrics. They are playing tic-tac-toe. I'm sorry. They're not paying attention. I got to see it. Can't wait to hear Judge Whitaker's reply. I think she will agree, but will allow the state to continue to disregard deadlines. Hope I'm wrong. I can't disagree because That's what we've been watching. So because we've been watching it, Pink been paying attention. See, Pink is a student that was paying attention in class. And she knows you got a propensity to go off the rails. I used to have a teacher on my grade level that you could say something, there's certain terms that you were guaranteed to get them off on a tangent. And the students kind of knew, oh yeah, if we say this to Miss Bumblebee, she gonna go off on a tangent for 20 minutes about this topic. And the students kind of knew it. And they would kind of mention every now and then, they would kind of say something about this topic. And Miss Bumblebee was off to the races. They knew 20 minutes. Pew! We want to waste 20 minutes before we go to lunch. Mention this. And now we got 20 minutes extra for lunch. We want to waste 20 minutes of science time. Mention this. That's crazy, right? So Pink right here is paying attention. She knows, like, Judge Whitaker has a propensity of not following along and holding holding the state's feet to the fire. Shout out to you. Thank you so much. They might be taking notes, but how long are the notes? What are they taking notes on? I could literally be sitting there writing, can I remember what the sermon was about yesterday? And I would try to write down as much as I could from my pastor's sermon yesterday. And then when I get home, listen to it and see if I caught everything. I'm sorry. Just because your pen is moving does not mean that, just because you're looking at me does not mean that you're paying attention. Taking notes and doodling? Come on, man. I'm drawing pictures. Well, good to have you retired. Thank you so much. I mean, come on. Again, I'm not trying to be disagreeable, but I'm like, there's no reason for me to believe that they're paying attention because we ain't paying attention sometimes, right? I think they have seen the entire circus. I think they recap all of this in their spare time. No argument at all. What's up, Amethyst Angel? They're not taking notes. They're writing their memoir. Why didn't I think about that? Because people keep saying that the jury is going to write books. And this is it. They're probably writing this down. Day 114 of being held hostage. I mean, I'm with you. There is zero argument from me at all. I agree. I wouldn't be surprised if there was a juror taking a little nap. Let me tell you, I wouldn't be surprised. It is insidious to believe that the jury is locked in. I'm sorry, there's no reason to believe that. I'm not trying to be disagreeable. I just cannot believe that the jury is locked in, focused, laser focused. No, I'm not willing to give you that. I don't think about this one, Will. Will says, I'm wondering if the YSL defense team is going to have to move to get this judge recused. She won't come down to the prosecution and come down on the prosecution and sanction them for misconduct. I don't know if that's a recusable offense, but please understand, if there's a legal expert that can explain it, I will definitely hear it. I don't know if that's recusable. It's kind of like saying, if I go to your house, we're kids, and I come to your house to play, you might the way you run your house is going to be different than the way my mom ran our house. So therefore, it is very possible that you do things at your house, your parents do things at your house that my parents don't do. That doesn't mean that we got to get your parents replaced. It just means the way you run it is differently. Now, if you're putting somebody in harm's way, if you're doing something that's criminal, of course. But we're just saying, hey, y'all get to eat, 2 scoops of ice cream after dinner, or y'all can watch TV like we couldn't watch TV and eat dinner when I was a child. So y'all get to watch TV and eat dinner. That's just different. It's not something. So I think each court gets to kind of run their own ship, I think. But that's a good question though. LaToya said they write love letters. Dear family, I love you. If I pass away, you can have my goldfish and little Sally can have the gerbil. I love you. They checked out at the point they were being held against their will. Yo, that thing is crazy. I agree with you. I don't know how to, and Tanya, there's not really, I don't know how people are determining these things about the jury. The jury is in a box that you can't, it's hard to see through. You really got to be, I don't know how people are doing this. So people are saying things about the juror. I don't know how they're doing it. My name is Jason. I'm trying not to get kicked out of court, right? So I'm not over there like staring through the window, looking through anything of that nature. I don't know how people are saying these things like they're taking notes and they know what they're doing. I don't know how you know what they're doing. So that being the case, that I don't know how they're saying that anybody's taking notes. Truth be told, I don't know how you're seeing it, but I'm just staying out of it. If somebody says that, then that's what it is. Thank you again, Will, for the very kind super chat. Thank you very much for that. If you have values, teaching can be a real battle dealing with the administration. Most of the problems with, and I'll say this, and please remind me, I will gladly do a video about teaching. Most of the problems that you have in education are very, very rarely around children. Most of the problems in education are adults. Now, that could be the adults that are teaching. That could be the adults that are administrating, the adults at central office, or the adults that are raising these children. Most of the time, teachers are trained to deal with children. They're not trained to deal with the adults that really the problems. Because a lot of the time, it's not really children. Children, a lot of the time, again, being very general, kids most of the time want to learn something. If you can just present them something new in a fun way, kids don't have a problem with it. Okay, fine. You're going to teach me how to tie my shoe. Oh, you teach me multiplication. Oh, you're teaching me whatever. A lot of the time, it's the adults, the grown folk, the people that pay taxes, the people that punch a clock. It's them. They cause problems in schools. Now, it might be you, the adult. It might be your coworkers, your administration, central office, the adults that drop the kids off. But a lot of the time, it's not the kids. It's the adults. Okay, that's it. Remind me, I'll do a story time about it. Yo, if the jurors' chairs were like those massage chairs, you know, like movies now have those very reclined, man, it would be nap time for sure. Oh, it would be nap time. The jurors need to have them benches that are in the gallery. Those benches are so uncomfortable. That's what the jurors, because it'll keep you awake. It'll keep you awake for sure. I agree. Lawyers are some pretty prolific writers. I like them. Now, I think sometimes they write too much, but this right here from Doug, hats off to Doug. This is definitely good. Hands down. They're writing their memoirs. They're getting it. Hey, I'm writing an outline. Chapter 1. I'm already on chapter 7. I got my outline going. Now the only problem is the only problem with the memoir idea. I just thought about it. The notes they have to give their notes, turn their notes in every day. I just thought about that. They can't take their notes home. So if they're writing their memoirs, they're giving their memoirs to the deputy when they leave out. And they can't have a phone, so they can't take pictures of it. So man, that's the only thing. We got to find a way to get that. Ooh, I like this. I think they should give 60 hours to figure it out. No more. I like that. Instead of 20 days, you got 60 hours. So what's that? That's a little bit better than a week of roughly. The Lululemon, let me tell you, Rebecca, don't tell nobody. I'm a Lululemon fanatic. Matter of fact, this shirt is a Lululemon shirt. It has a lot of L's in it. So I'm trust me. Now the logo does not have L's in it. No. Matter of fact, you can probably see the logo if I turn around. The logo does not have L's in it, but I was making fun of their name. All right, but here, I think that would be fun. Like set an hour limit. Then you could have a true shot clock, like 60 hours on the clock and it's just ticking down. That would be crazy. That'll turn into that'll move it along though, for sure. What's El Chapo say? I'm sorry, LK Chapo. Doug might be YSL's ghostwriter with that pen work. I like it. I like it. I like it. I like it. That's what's up right there. All right, what we got? Oh, another. Thank you again, Will. State will do what is allowed to get by with. See, that's it. That is it. Yeah, like I'm gonna go back and say this again. What we're watching right now in Judge Whitaker's courtroom would be absolute, unequivocal pandemonium if it were an elementary classroom. If the teacher says XYZ ABC but doesn't hold children accountable for it, and children are allowed to not be prepared and not have the homework and blame little Johnny across the way or little Sally in the other chair, it's their fault, they would have pandemonium. I'm sorry, in any grade level, from pre-K all the way up to fifth grade, if you did this in a grade school, in an elementary school, it would be pandemonium. I mean, it would be insane. That's why I said I think it would probably behoove Fulton County to do a career swap with a classroom so they can kind of see. Because I think Judge Whitaker would really benefit from seeing what it's like to manage, because all of these shenanigans, all these motions, all of these briefs, when you go to an elementary classroom, those are little tiny humans. So this motion right here that Doug just filed, that would be a little human. What are you going to do with it? Or the unpreparedness of Adrian Love, that's a little person. What are you going to do with it? The way she's dealing with it is not tenable in a classroom. And I think it is transferable to be able to manage all of these motions, all of these little wrangling. I used to say, I'm a cat herder. I'm a professional cat herder. And I'm just trying to get all the little cats going in the same direction and praying I can do it again tomorrow. And it's funny because I have allergies and I'm definitely allergic to cats. So people knew, like, Jason trying to get these cats getting away from as quick as possible. I just don't think that it's a lot. To your point, thank you, Will, for the very kind super chat and the support of the channel. You can't do this in a classroom. It just wouldn't work. Judge Whitaker's hair would be flying all over the place. She'd be pulling her hair out if she was a classroom teacher. She gonna be lying at the podium. I know one thing for a fact. I don't know if she gonna be lying, but there's gonna be some finessing happening up there today for sure. There's gonna be some finessing going on. How do they punish the state? You can't, you no more. Make them, when they don't bring their homework today, then therefore they now lose opportunities to bring up more witnesses. Or, for example, if they don't do it, then this witness is done. We're finished with this witness. Imagine if Judge Whitaker said, we're done with Woody. You're done. It's over. State, go have a seat. Doug, Brian, y'all ready? Cross-examine. Let's go. I bet you they would stop now then. They get their ducks in a row. Because also remember, they're supposed to submit a witness list. Shaded Shabazz, thank you so much. Shadid Shabazz. They're supposed to submit a witness list and say what each witness is going to do. So if they look at it and say, wait, hold on. You got 5 people from the Hertz rental car company. Y'all don't need no 5 people. You need 1 person and that's it. That's how you punish the state, in my opinion. Yeah, most of us, if you're not prepared for work, you got a little, let's just say that you won't have so much bread in your pocket. Okay. That's pretty straightforward, but they get away with, they get to do it like wholesale. There are no consequences for them. Because trust me, as sure as my name is Jason, if the defense was as unprepared as the state is right now, they would be raising Cain. If Brian Steele was like, oh, I don't know what I'm going to say. I don't have this, that, and the other. They would be raising all kinds of Cain. But and I just want to make sure I say this again. I've said this on other streams before. They don't really have new evidence. There's not new evidence. Those videos that we're watching are from 2014, 2015. You mean to tell me that y'all couldn't have gotten that? Fulton County cannot get an editor. I own a podcast studio. I'm here at my house, but I actually have a podcast studio on the Marietta Square. We have editors. You can go to Fiverr, for crying out loud. We have editors. You can have an editor. Fulton County can't afford an editor. So that's why we're watching all of this painstaking death by 1,000 tin can videos. That's what they're saying. Okay. There's a lot of room to rein in the state. What does she say? What does Texas T say? Whitaker is going to let love get away with it again. Come on, don't say that. I kind of believe you, but don't say it like that. It hurts. Because Weinstein was cooking here. He was cooking right here. You know what, Texas T, I got to disagree. No, I'm going to hold out hope. I'm going to lose that bet. If I lose it, I'm just going to lose it. But no, I don't think she's going to let that slide. Because it's too clear. And she's also irritated. Judge Whitaker is not cool with this. She's not. She's irritated. If you listen to her early on to how she sounded on Friday, her voice tone has changed. It's kind of like your mom when y'all playing in church and she looked back behind you. She giving them that proverbial stare like y'all about to get it in this fellowship hall in a minute. Wait till we get out in this car. And she's giving it to him. I'm not gonna. No, T. I can't let it happen. No, I can't. What does Regina say right here? Love will have a computer glitch. Because you know that's gonna happen. You know it's gonna happen. Judge Whitaker knows what to do. She won't because the ghost of Glanville. Stop it, Regina Supreme. Stop it. Because you're probably right. You're probably more true than false. I mean, you in Texas T, y'all probably right. But I just don't want to give up. I just don't want to give up. They are reintroducing evidence. It's things they already argued. It's unorganized and they can't even follow it. I agree. These clients are in jail. Yes. I mean, that's something I don't think. And again, I think Doug made it really clear. Like, y'all get to go home. You get to go to the crib. But these guys are in Rice Street. These guys are in jail. While you are enjoying your weekend, their weekends are in jail. Man, that's messed up. I agree with you, man. He did a great job of making that very clear. Boy, LK Chapo said the only thing the state is prepared for is for their excuses. And that is true. There is no dearth of excuse management up in this piece. This is what happens when you have nothing solid. I got to get that little meme of the little character kind of looking off to the side of the little boy. Because that's it. Like, if you had something solid, trust me, if you had a solid case, you would have given that. If you had solid evidence, you'd have given it. What do we have? Yeah, this is what we have. I have no faith in the new judge. She's protecting Glanville. So, some reason or another, the jury is not there. So all this week, today they're starting at noon. Tomorrow they're starting at noon. I think it's normal time the rest of the week. And they're just kind of horse trading, going through motions, hopefully paring down this witness list and getting down to some very salient points, maybe installing the shot clock behind Judge Whitaker. And they got like 50 hours. And okay, here we go. You start with, I'll give you 75 hours. You got 75 hours left. Okay. However, every time you don't have homework done or every time you get a slap on the wrist for doing something, so much time is deducted from the 75 hours. So let's just say no homework is a 5-hour penalty. So they come in tomorrow, they had 75 hours, they don't have their homework done, they were supposed to have pared down the witness list or got to the salient witnesses, they don't have it, 70 hours. Excuses, 1 hour. Just Brady violations, technical foul, game over, whatever. But I do think they should install a shot clock. A shot clock would be crazy, but let's just tell the truth. It would be very entertaining. Yeah, I don't think, again, I'm not convinced that they're writing it down I'm not convinced that they're writing notes about what's going on in court. But even more than that, to Melanie's point, writing it down doesn't mean you're going to remember why you wrote it down. I can only tell you how many times I've done that. I write something down, I'm like, what the world was I thinking? All right. That's a very interesting conversation. Thank y'all so much for jumping into the chat. I appreciate the back and forth, the family reunion, stuff like that. The defense doesn't want more delays. I don't think the defense has ever wanted delays. But I mean, there's some delay tactics that they've used. I will say that. They've done some things that have been a little slow it down a little bit. But it's not because everything was moving fast. So let's just say that. why are they giving them so much time? I don't know. I want her to make a decision today. But let's, you know what? To her credit, she might not make a decision today, but she should make a decision before the balance of the week, before the jury comes back. Because technically, literally, they're not going to do anything until the jury comes back. They're not going to really make progress until the jury comes back anyway. So therefore, I'm pretty sure she's going to at least punt it till tomorrow. She's going to say, oh, I got this and I read it. Now, if she comes in and surprises us and makes a decision, I will be thoroughly surprised. I'm not really hoping on that, though. I'm not betting on that. Why are you like this, Bora? Why are you like this? Bora said Atlanta's going to honor these jurors with a parade after this. And the bad thing is I could literally see it in my head when I read it. That is hilarious and probably true. I hope it's not. All right. I appreciate y'all so much. Now, court is going to start at, matter of fact, let me make sure I got that ready. Court is going to start at noon today. Now, this question has been kind of going around. Does that mean she's going to go all the way to 6 o'clock? They're going to get a lot of work done. They're going to get a lot of work done if they go from 12 to 6. That's going to be more work than they've gotten done in a long time. So I don't know how that's going to work, but we will truly see for sure. I mean, I would definitely be doing some voice notes. Maybe they have access to their phones when they go to the jury deliberation room or whatnot. It's not deliberation. If they go to the jury room or whatever, maybe they have access to their phones and they could do like some voice notes and whatnot. But yeah, I mean, being a juror in the longest trial in American history, or at least in Georgia history, that would be that would be compelling for sure. Truly, everybody in that courtroom could write a book. The judges could write it. The court reporter, the clerk, witnesses, the juror. Everybody's been held hostage in this thing. There's not many teachers that would get away with the stuff that Adrian Love is doing. If you were a teacher, I'm sorry, you would not be getting a contract. You would be put on a PDP. You would have to have a co-teacher. They can make your life miserable. The stuff that Adrian Love is getting away with would not fly. Even in the worst run elementary schools. That right there is not going to fly. Ooh, that'd be great question. If the state only had 1 week to present their case, who would their witnesses be? I like it. I don't know that, but I think that's what I'm saying. Like if they had a shot clock, you got, what's that? 5 times 8 hours, so 40 hours. You got 40 hours on the clock. There's a big old shot clock behind Judge Whitaker and you got to go. Because by Friday, when it hits 0-0 or whenever it hits 0-0, you're done. But this is the only thing though. Usually each witness gets direct and then cross. So how does that work? Would the defense also have to move it along too? Because I can see the defense. What if the defense takes too long? That's the only thing. We got to work this out, though. We're going to come up with a new idea. Shot clocks in court. Monica said, can the people following this trial give your opinion about the guilt of the defendant for murder? The victim is lost. I am not convinced. Watching what I've seen so far, Monica, and I'll just answer it. And we got about 20 minutes before court starts. And because I'm going to end this stream and then we're going to start the next one. I am not, well, first of all, I do believe that somebody was unalived. I do believe that Donovan Thomas was murdered in, was it 2014? I'm not 100% certain that all of the 6 defendants were involved in that. I have my own theory what may have happened, but I don't believe that those men of Donovan Thomas's unaliving. Now, are they a gang? Were they doing gang type stuff? I believe there's more evidence to that, but again, still, I'm not conclusively convinced that they were a gang or they're doing gang stuff. Were they doing things? Probably. Let me say it like this. They were not Vacation Bible School students. Okay. They were not out here, helping little old ladies walk across the street and rescuing kittens out of trees. No, I'm not pretending like that. Are they as bad as the state is trying to make them out to be? I don't know. And I think that's part of the problem. We don't know because the state has done such a terrible, terrible job of prosecuting this case. So I don't know. I'm not convinced that those men did that. I have a theory again about what happened to Donovan Thomas, but that's beside the point. Some of the things that they're being accused of, they probably did do that. But a lot of that stuff they're making them guilty of, or rather accusing them of and saying they're guilty of doing, is stuff that we all did. So I'm like, I don't know. I'm not seeing the connect between this is a gang because they did X, Y, Z. I'm like, we did that too when I was a kid. Like, what are you talking about? I don't get it. So a little 2 cents, but thankfully I'm not a juror. Thank God I'm not a juror. Thank you. Oh my goodness. Thank you.
Hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.